Morning, ladies and gentlemen. Good morning to the Joint Select Committee on the amendments to the Tobago legislation. Good morning to all our viewers and listeners who are viewing these proceedings on the Parliament channel and other platforms. I want to welcome you to the Joint Select Committee on the Tobago Amendment Act to deal with the self-government for Tobago. Thank you very much for taking this time to be with us, and thank you very much for the interest that you're showing in this particular piece of legislation. Today we have with us several persons who I will ask to introduce themselves, but before I do that, I would like to ask members of the committee to introduce themselves, and then we'll ask those stakeholders who are with us to introduce themselves. Again, thank you very much for being here. So I'll start with the members in Trinidad and then move on to the members in Tobago and then to those stakeholders who are here with us. Thank you.
Najinder Singh, member, a pleasant good morning to all.
Member. Good morning.
Good morning to everyone. Dinesh Rambali, member.
We'll move to the committee members.
Madam Chair. As
Yes,
I'm on the
AG.
outside, good morning in isolation. It's Faris Al-Rawi, member.
Good morning, everyone. Renuka Sagram Singh Suklal, member. It's a pleasure to be here.
Good morning, everyone. Shamfa Kudjo, member.
Good morning, everyone again. Nigel Lefritas, member.
Good morning, Maria Dillon Remy, member.
Good morning, Clarence Rambarat, member.
Thank you very kindly, members. I'll now ask those who have joined us to introduce themselves, please.
Good morning to the chair and members of the Joint Select Committee, Ho Choi Charles, member of the Forum of Political Parties, and I have with me the two other members who have been attending the Joint Select Committee meetings, Mrs. Juliana Henry King and Brother Samuel Mapp. They are here with me, only two members.
We're just checking to see if there are any other of the stakeholders who are on already. Mrs. Webster Roy, are you here with us?
Good morning, everyone. Ayana Webster Roy, Member of Parliament for Tobago East.
Is there anyone else there with you?
I am not seeing everybody else joining us yet.
All right, but we will start, and thank you very much again for joining us. And I will start. Okay, I understand that Senator Farmer Dayal Singh is also here.
Yes, I am. Good morning, Madam
Please
Chairman.
introduce yourself. Yes.
Yes. Farmer Dayal Singh, Independent Senator. And morning all, and pleasure to be here.
Thank you very much. As you know, members and listeners and viewers, this is being done virtually. So we will have a few hiccups, but we're hoping that we will have a smooth flow today. So thank you again for joining us. I'd like to open this morning's meeting by giving you some brief opening remarks on my behalf as the chairman of this committee. As you know, we have had this assignment, and we have tried to make sure that we have followed what we have been asked to do. The Joint Select Committee of the Parliament of Trinidad and Tobago on the Constitution Amendment Tobago Self Government Bill 2020 is very pleased to resume these consultations, particularly with the people of Tobago. This is a very important legislative proposal, and we are happy to welcome all those who will be joining us at today's consultation. As you know, these consultations actually began many years ago. Many of you in Tobago will recall the island-wide consultations that took place over the period 2014 to 2016, and this culminated with a debate in the Tobago House of Assembly. The output of those discussions and debates was a draft bill to amend the Constitution of Trinidad and Tobago to accord self-government to Tobago. This was the genesis of the bill that was laid in the Parliament of Trinidad and Tobago in 2018. This bill was sent to a Joint Select Committee in March of 2018. Over the period 2018 and 2019, that committee called for comments and submissions and held a series of public hearings with stakeholders and experts from Tobago and Trinidad, as well as legal and other experts with knowledge and experience in relevant constitutional matters from a number of other jurisdictions. The life of that committee ended in 2020. Upon the resumption of the new Parliament, the bill was referred to a new committee in November of 2020, and this is the committee that is before you. With the aid of the body of research inherited from the last committee, the new Joint Select Committee set about its work. This committee has since circulated our preliminary findings and proposals. Today, we begin receiving your comments. We begin in Tobago since this matter is exceedingly important, particularly to our Tobago brothers and sisters, and particularly because the original piece of legislation came from Tobago. Since the circulation of the draft proposals, we have been encouraged by the fact that there have been robust conversations on the bill all over Tobago. This, ladies and gentlemen, is democracy at work. We of the Joint Select Committee joined those conversations today. This committee is interested in all comments. This is the process of lawmaking. We assure you that, mindful of our mandate, we will take all comments on board. Against that background, allow me a few minutes to brief you, the people of Tobago and the people of Trinidad, on the committee draft proposals. The proposed revised Constitution Amendment Tobago Self-Government Bill will alter the Constitution of Trinidad and Tobago to enshrine into our Constitution certain rights exclusively to the island of Tobago. Tobago will become an autonomous region, free to pursue its economic, social, and cultural development and physical development to the extent possible and within the framework of the Constitution of the sovereign unitary state of Trinidad and Tobago. The Constitution will now establish the Tobago Island government. Staff who work for this government will fall under the umbrella of the Tobago Division of the Public or Teaching Service Commission as proposed by the committee. Also, the Constitution will establish a completely new Tobago Legislature with the ability to pass laws for Tobago that will come into effect on assent by the President, similar to the process followed for the enactment of laws by the National Parliament. The committee is also proposing a companion bill to repeal and replace the Tobago House of Assembly Act. This bill will provide the powers and functions of the Tobago Island government and set out workable financial and other arrangements for matters regarding the operations of the Tobago Island government and the legislature. But this is not all. The draft proposes that the reformed Tobago legislature should be a unicameral legislature comprising of a reformed House of Assembly and the President of the Republic of Trinidad and Tobago. Unicameral legislatures are not uncommon. In fact, in the Caribbean, there are several examples of legislatures that are unicameral, including but not limited to Dominica, Aruba, Nevis Island, Guyana, the British Virgin Islands, St. Vincent and the Grenadines, the Cayman Islands, and the US Virgin Islands, to name just some of them. The committee carefully studied the advantages of these models and found some to be quite useful to its work. The proposed new Tobago House of Assembly will comprise 15 elected assemblymen, 5 councillors appointed by the President on the advice of the Premier, 3 councillors appointed by the President on the advice of the Minority Leader, 2 councillors appointed by the President in his or her own discretion from amongst outstanding persons resident in Tobago from economic, social, or community organizations or other fields, and a presiding officer who may or may not be an assemblyman or a member of the Tobago Executive Council. There is now a provision for the appointment of councillors to temporarily fill vacancies due to illness or absence from the country of appointed members. The Constitution will be amended to empower the members of the new Tobago House of Assembly to make laws for the peace, order, and good government of Tobago, and such laws will be called Tobago Acts. Laws that can affect fundamental rights and freedoms of the citizens of Trinidad and Tobago will remain under the jurisdiction of the National Parliament of Trinidad and Tobago. Additionally, broad policy issues for which there is the need for the harmonizing of laws will also be the responsibility of the National Parliament. This is to ensure that there is no conflict of laws. The 4th schedule of the Constitution will list the areas for which the Tobago legislature will have exclusive lawmaking powers. The question may be asked, why is there a need for such a schedule? This arrangement is necessary as it promotes legal certainty, and this is required by both the National Parliament of Trinidad and Tobago and the Tobago legislature when making laws. Whilst some aspects of the functions of the Tobago legislature will be in the Constitution, a companion bill provides for operational matters and proposes several oversight committees to be established within the legislature to oversee the work of the Tobago government. Therefore, the new Tobago legislature, like other parliamentary bodies, will be lawfully required to fulfill the following roles. 1, lawmaking, 2, scrutiny of the government. 3, representation of the people of Tobago. As a legislature with the power to make laws to affect the lives of its people, the Tobago legislature will finally be able to take a seat at international assemblies where legislators meet regularly to discuss matters related to their role and functions. So, the Tobago legislature will be able to speak for the people of Tobago and leave its mark on the international stage. I refer now to Clause 11 of the bill, because Clause 11 amends the Constitution to accord the new Tobago Island government exclusive executive powers to manage all areas listed in a 5th schedule of the Constitution. The Tobago government will be managed by an executive council comprising a premier, a deputy premier, a secretary for legal affairs, and such other secretaries as may be necessary to govern the affairs of Tobago. This new arrangement we propose will deepen Tobago's autonomy. Civil matters, including and involving the Tobago House of Assembly and the Tobago government, will now be handled by the division of the Secretary for Legal Affairs. As is the case today, the Tobago government can be empowered to act on behalf of the government of Trinidad and Tobago in respect of any of its residual responsibilities in Tobago by way of a memorandum of understanding arrangement. The Premier for Tobago now has to be consulted before appointments can be made to certain posts like the Chief Administrator, administrators, heads of departments in a division, and the Chief Professional Advisor. The proposed amendment to the Constitution will require the President to act in accordance with the advice of the Tobago Executive Council or a Secretary acting under the general authority of the Tobago Executive Council with respect to matters in the exclusive jurisdiction of the Tobago government. This patterns the law related to matters in the exclusive jurisdiction of the central government of Trinidad and Tobago. Should there be a conflict of any kind between the government of Trinidad and Tobago and the Tobago Island government, the bill proposes that the parties be legally required to make meaningful efforts to settle these matters before any attempt is made to approach the courts. Ladies and gentlemen, the draft companion bill entitled the Tobago Island Government Bill proposes financial arrangements for the management of Tobago's funds. The bill proposes that Tobago be appropriated 6.8% of the annual appropriation as a minimum. However, the law further provides for increases over and above this sum on the recommendation of a fiscal review commission. The Tobago government will be empowered to retain all revenues collected on the island. The draft bill provides that a Tobago fund be established to consist of monies appropriated by the Parliament of Trinidad and Tobago for the use of the Tobago government and such other monies that the Tobago government may lawfully collect, borrow, or earn through investments or may be granted. There will also be a contingency fund to provide for unexpected expenditure. The rules for the management of all finances of the Tobago government are required to be debated and approved by the Tobago legislature. No longer will there be the need to send estimates to Trinidad for approval. The Tobago Legislature must now also debate and approve its own Tobago Appropriation Act, which, together with detailed estimates, must be laid in the House of Assembly. The members of the Assembly will be required to examine these estimates and seek information from the Executive Council on proposals for expenditure of Tobago's funds. All of this will now be part of the new Tobago budget process and is in keeping with the arrangements in legislative bodies worldwide. Quite significantly, this bill provides for the establishment in law of the following committees, and these will be committees of the Tobago Legislature: a Public Accounts Committee, a Public Administration and Appropriations Committee, and a number of other oversight committees to scrutinize the operations of the Tobago government. What this means is that the expenditure of Tobago's funds will be exclusively decided in Tobago by Tobagonians with oversight by the Tobago Legislature, both during and after the budgetary process. As I said when I opened, this is a very important moment for Tobago and for Trinidad and Tobago. This is a momentous period for the people of Trinidad and Tobago. We do feel a degree of disappointment that the prevailing circumstances, the so-called new normal, does not allow us to commence these consultations with face-to-face meetings. But we are of the firm view that we are resolved to hear from you, and so we begin today in this virtual space. Thank you very kindly, and so we begin. So, ladies and gentlemen, I begin now to hear from those who are with us. I know that Mr. Ho-Choi Charles is here, and I'll ask him now to make a brief opening statement and let the discussions begin. Thank you very much.
Thank you, Madam Chair. Are you hearing me?
Yes, we are.
Thank you. You have, in your closing, somewhere in your closing remarks, you did say you're disappointed, but I am disappointed for another reason, not the one you gave, because of the lack of our ability to meet face to face. I am disappointed when I looked at the result of 6 years, I believe, of, I may call it work or matter in your presence. But let me just put this thing in context. And we speak so much about democracy. And I want to remind all of us what democracy means. Democracy is a form of government in which the supreme power is vested in the people collectively and is administered by them or by officers appointed by them. So the supreme authority is vested in the people collectively total. And what we are discussing today is the matter of internal self-government for the people of Tobago. And I want to just very quickly, I have been involved in this matter for a long time. And in fact, from its inception before 1976, after the elections of 1976, including all the drafts, all the documents, all the legislation that came out of Parliament, that in fact had not provided Tobago with the decision that had been made in 1977. the decision made by the Parliament in 1977 on this issue after the motion, that historic motion by Mr. Robinson, was that Tobago should be accorded self-government in the year 1977. We are now in 2021, and we are still discussing that particular matter. You made reference. I am going to try to be brief because you asked me to make my comments brief. But I don't understand how we can come to be discussing a matter of this kind and our comments. Of course, we need to be restrained and constrained. A matter like this, having regard to the journey that we have made on this issue, to be brief in these comments. After you, as the chairman, would have spoken so extensively at the beginning, and you have that right, you have my permission and my agreement to do so. But I should not be circumscribed in this way. Let me just say this quickly. Why, in my own view, and I will give you why and the authority that was given to the organization that we call the political forum. The authority given to us in order to prepare the document which you call the draft bill that was sent down to you in 2016, I am going to just read the motion so that the Parliament understands the context of what we are discussing. Remember everything we say and we are saying today. Remember what we are discussing. We are discussing internal self-government for Tobago, which is in fact a principle, and in fact is a covenant of the United Nations that says that all people have a right to their self-determination. And it went on to say that would also mean that we will freely determine our political status, and then we will be able to pursue our economic, social, and cultural development. That's international law. They have made it international law, the United Nations, because their view was in 1952, and it still is, that the General Assembly of the United Nations recognized in 1952 that the violation of that right of people and nations of self-determination had resulted in war in the past and was considered a continuous threat to peace. And that is why they have decided to make sure that this issue of self-determination is put in international law. What I have seen come out of this document before I read the motion is that the document that have been prepared and sent back, both bills, the amendment to the Constitution and the Tobago Island Government Bill, both of them are in violation of that, really in violation. And I would say this, that the people of Tobago met, and you refer to it, and that is quite true, the extensive consultation which took place between 2013 and 2016. And I can testify to it because I have been with Mr. Robinson and the others. In fact, I'm one of the architects of the international government motion that was moved in Parliament in 1977. So I have been journeying. I am a history maker where that is concerned. I have been journeying down. So if I tell you now that the consultation that we had in Tobago on that issue between 2013 and 2016 was the most extensive, I know what I am saying. That's not theory. It's not an opinion. And that consultation resulted in a motion at our final meeting at Signadale, which authorized what we have said to you. And let me say that, and then I will quickly tell you what I think about the provisions that you have made very quickly, not going to all of them. Let me read the motion. That is what informed and instructed us. And this committee needs to know that. The Parliament and the world need to know that the people of Tobago, I mean unanimously, we can say, agree on what we have sent to you, and you have violated that. You have gone contrary to that. So let me read the motion. You need to read it into your records. Every single member of Parliament. The United Nations need to hear too. Every one of you need to hear this. After the wide consultation of which the chairman also referred to, and she was accurate and quite true, because I'm sure she was properly informed of that. That's quite true. There's a motion in Signal, moved by the lady who is at my side. Juliana Henry King moved this motion at Signal. All of us are there. Tobago came there to that meeting. And let me read the motion very quickly for you. Let me take my time with it. The issue of democratic self-government for Tobago has engaged the people of the two islands, Trinidad and Tobago, since the Union of 1889. And whereas the need to establish an appropriate Tobago self-government has been recognized by all participants in the national arena since 1977, but remains an outstanding goal of the Tobago people. And whereas, in consideration of the issue of Tobago self-government, useful points of departure or reference for the establishment of Tobago's right to self-government can be found in the provisions of the Constitution of Trinidad and Tobago, in the Constitution of Trinidad and Tobago, the decisions of the Parliament of Trinidad and Tobago, the assertions of universal and international entities, and the conventions of natural justice. And whereas specific citations that support Tobago's right to self-determination can be found in international law and conventions, particularly the United Nations Charter, the United Nations Declaration of Human Rights 1948, the Declaration on the Granting of Independence to Colonial Countries and Peoples 1960, which states all people have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. And finally, 4, the International Covenant on Economic, Social, and Cultural Rights of 1966. And whereas every other system of governance other than democratic self-governance has been tried in Tobago and has failed. And whereas the Chief Secretary and the leaders of the 3 political parties contesting the Tobago House of Assembly elections 2013, namely the People's National Movement, PNM, the Organization of the People, TOP, and the Platform of Truth, TPT, conscious that the most fundamental right of human beings in society is the right to self-determination, convinced that the time has come to attain democratic self-government for Tobago, recognizing the need for the people of Tobago to speak with one voice on the issue, have submerged their individual political agenda and agreed to constitute a forum of Tobago political parties for the principal purpose of working together to attain democratic self-government for Tobago, the single most important goal of the Tobago people. And whereas the forum, conscious that the populations of the islands, the communities, families, and individual citizens that constitute the Union have never previously been fully informed, consulted, or engaged on the issue over these years, and that the conversations, debates, agreements, and edits sought, reached, and proclaimed have been a matter for governments at the colonial offices in London and in Port of Spain. And whereas the process, consisting of a series of consultations entitled Towards Tobago Autonomy, has engaged the population of Tobago living in Tobago, Trinidad, the Caribbean, and the wider diaspora, has examined the proper way forward for Tobago and sought consensus on 1, issues fundamental to Tobago self-government, 2, issues fundamental to Tobago in its relationship with Trinidad, 3, a set of core principles that transcend political differences, and 4, a process for inter-party consultation on fundamental issues relating to Tobago. And the resolution, I want you to hear it well. The world must hear it. Be it resolved that this convention of the people of Tobago, meeting here at Signal Hill Secondary School today, September 14, 2014, A, agrees and asserts that the issues fundamental to democratic self-government for Tobago include inter alia, 1, responsibility of the Tobago administration to formulate and implement policy on all matters affecting the lives of the people resident in Tobago. 2, equality of status between the islands and a constitutional, legislative, and administrative framework reflecting such equality. 3, and I want you to hear this well, 3, a federal type system of government. 4, delineation of the boundaries of each island. 5, jurisdiction and control over economic resources in Tobago's defined geographic space. 6, freedom for Tobago administration to make laws to govern Tobago. 7, ability to borrow and to fund Tobago's development. Let me read that again. Ability to borrow to fund Tobago's development. 8, authority and responsibility in the Tobago administration to formulate and implement fiscal policy, including taxation measures. 9, removal of cabinet dominance and override of decisions made in Tobago by the Tobago administration. 10, legal framework providing for the wider participation of the Tobago society in the decision-making process of the Tobago administration. 11, management and control of the inter-island transportation system to reside in Tobago. And B, the convention hereby authorize, instruct, and they deliberately use these words, hereby authorize, instruct, and mandate the forum of political leaders to take all proper and necessary steps to achieve and secure democratic self-government for Tobago in the shortest possible time. And C, requires that the forum ensures that the self-government secured for Tobago includes the appropriate provisions to treat with the issues agreed and asserted at a 1 to 11 above. Now,
just a minute, Mr. Charles. Thank you very much for that introduction. And I know that you will go on to your detailed discussion of the bill that's before us. Let me just intervene here by saying, first of all, that was not the context of the bill that came before the committee that was set up to deal with this issue. You would recall that a bill came before the committee from Tobago. And some of those things that you have stated that were in the resolution, some of those things were not in the bill that we had to deal with. So let me just put that on the table from the outset. Secondly, with regard to the International Covenant of Civil and Political Rights that is stated by the UN, let me indicate that the interpretive guidelines of the UN specified specifically that these applied to federations where there was already a certain separation, and they did not apply to governance systems where the intention was to create or to maintain a unitary state where there would continue to be that unitary status. And we did not have any instructions to create a federation. So let me just put those things on the table. So could you tell us now what in the bill that is before us, what the concerns are that you have? Thank you.
These resolutions, I could, and I don't want to do that now. I would have been able to tell you in the document that you had that was submitted to you, which section deals with these matters. I can also say that there may be one or two of those issues in the drafting that may not have been in accordance with what the people would have said, but almost all of them in the bill that was sent down. Secondly, I understand that the right to self-determination does not necessarily mean independence. It means the right, it means the freedom to exercise option. And one of the option that Tobago exercises in this case is that we want to remain a sovereign democratic state. I am hearing it come out of Parliament several times about unitary state. We avoid using that word in Tobago from ever since, and there's a reason for it. Because Trinidad and Tobago can be considered, as you say, a unitary state. Our constitution doesn't say so. Let me say that the United Kingdom is also considered a unitary state. And there are some dependencies like Guernsey, Jersey, the Isle of Man. They are almost independent, although they have one sovereign democratic system. And may I say finally, Madam Chair, that Germany was also a unitary state under Hitler, one-man rule. So we avoid that.
Thanks very much for that. But could you, if we go to the bill, you can probably let us know what are the concerns you have with the various clauses.
Ma'am,
I'd appreciate that.
The bill as it stands, every section, even preamble, violates every single one of these things that I just mentioned. Beginning from, let's even look at the...
Yeah, go ahead and tell the committee.
Bill, you're hearing? That the draft
Please go ahead.
Let me just look at it. The draft bill confirms the recognition of the equality of status between the island of Tobago and the island of Trinidad within the unitary state of Trinidad and Tobago. There is
Could you, Mr. Oh dear. Yeah, we'll ask him. Mr. Charles, we are not hearing you. Are you hearing me?
I am hearing you very, very clearly.
Now, what would help us, because remember what we're doing is a consultation, and we are trying to make sure that we understand everything that you are saying and what would help us. If you're saying that this is not what is wanted, can you say what you would want instead? Tell me how you would want it made different.
No, I'm saying that the statement that is made is what we submitted to you. We submit this thing to you that there must be equality of status between the two islands. The statement I'm making is that the document that you submit, the bill, there is no provision in that bill that will give effect to that statement that you made there. We submit that we should be equal in status, but the bill you produce does not make any provision for that to happen. Just a statement you made. And that's the point I'm making with respect to that item. And we can go down. You said that the preamble to the Constitution, the second paragraph, The preamble to the Constitution of the Republic of Trinidad and Tobago will be amended to acknowledge the right of the people of Tobago to determine in Tobago their political, economic, and social and cultural state development. Every single provision, I mean everyone, I'm not exaggerating, every single provision of the bill is in violation of that. That we are under control in every way possible. The cabinet can override everything.
All right. So you're saying there that clause 4, you're saying does not reflect what was in the bill that came from Tobago. Because what would help us is if you went through it, if you wish, go through it clause by clause and give us your suggestions, please.
What we expect you to do, what we expect the committee to do, and I think that that's the point I've been making, I'm trying to make all the time, that's why I started off with democracy. That it is the people of Tobago that must determine how Tobago is governed. And that's the third item I read in the motion. When the motion says, let me go back to it and tell you why we drafted
Mr. Charles, you see, what we're trying to do is to make sure that what we are discussing is the bill that's before us. So it would help us if you said clause 4, you wanted this amendment to be made. Clause 5, we would prefer if it's stated this way. That is what would help the committee to be able to understand so that we know if such a change can be made, how it will make the bill in its entirety a little different. So if you could assist us in that way, that would help the committee. Because we have heard what you told us and we understand your general thinking. But if you were to go through the clauses and give us some idea of what the changes that you would like to see.
I have looked, I received these things a day or two ago, and I have looked at them, read them, and I'm saying to you that we would have submitted that Tobago should have equal status. It means then that for that to happen, and you are well aware of this particular issue, you are well aware of this particular issue. We have said that the Tobago and Trinidad should have equal status. And to do that, for Tobago to walk side by side with Trinidad and to have equal status, it means that the level of the administration in Tobago, the issue of the governance structure for Tobago must be at the level of Trinidad. What we have in the bill is one superior and one subordinate. And that is not what we submit to you. And that's what I'm saying, that has to be amended, it has to be completely changed. For Tobago to walk side by side with Trinidad or to have equality with Trinidad, it means that the level of the administration in Tobago, this requires whole drafting. And if you give us a chance in Tobago, we could draft it in 2 weeks and send back a whole new bill for you in keeping with what the motion that was passed and in keeping with that international law that I spoke about. We'll draft that. But what you have been attempting to do, what the committee has been attempting to do, is to determine how Tobago is governed. And that is what we said, that there are two issues, and I'm going to come to the specific. There are two issues that are involved here. One is the fundamental, the issues that are fundamental to Tobago Self Government. That's.
You're not hearing him. Mr. Charles, let me assist. Okay, clause 4. Clause 4 of the bill says this is...
I'm just asking them to get the bill for me, to pick out the bill. I just have it in the whole form that I just...
Right, so clause 4 states very clearly that the preamble of the Constitution would be amended by inserting after paragraph C, a certain paragraph. And this is what we got from the bill that came to us from you. Now, clause 5 similarly indicates that there will be equality of status, and it says that very clearly, there shall be equality of status between the island of Trinidad and the island of Tobago within the sovereign democratic state of Trinidad and Tobago. It says quite clearly about equality of status. Clause 6 gives a definition of various, defines various words in the bill, and which would be part of the amendment to the Constitution. Clause 7 defines what is the Tobago Legislature as it relates to the Parliament of Trinidad and Tobago. Mr. Charles, you're hearing us?
I'm hearing you, but you're
Right.
not giving me, so it's when you are through, because I can't intercede while you are talking.
No, I'm just saying that if we go through it like this, if there are any issues, you can raise it at the
Yes,
time.
I am. And I am saying to you, when the preamble, which you said refers to clause 4, says that the Constitution will be amended, what we have before us is the amended Constitution. Is the amendment to the Constitution. And I'm saying, because this says that the Constitution will be amended. What you have before us today is an amendment to the Constitution. And my statement
And that's the intention.
provision there which give effect to that fact that we should walk side by side.
Okay, but we have said that there will be equality of status. In the
saying
next
it,
clause,
but
we
you
have
get
spoken
provision.
about the equality of status. And Mr. Charles, let me just say for your benefit and for the benefit of all those who may be listening, that once we are intent on maintaining the unitary state of Trinidad and Tobago, which were the instructions that we received, there will be certain things that we have to put within the Constitution and other things that are in the companion bill that give effect to this unitary state, but always according to Tobago the right to ensure that what they do relates specifically to internal self-government for Tobago. And you will recall, because you did come to some of the sessions that we had, that we met with the United Nations personnel, we met with the former Attorney General of St. Kitts Nevis, who explained all of these things to us. And our intention throughout as a committee has always been to ensure that we give Tobago what Tobago wants within the unitary state of Trinidad and Tobago. And consequently, these are the clauses that we have presented to you today for us to discuss. There is no intention, and there has been no intention to move away from the instructions that we got once we can ensure that those instructions manifest themselves in such a way as to maintain that you did not ask for independence and you did not ask for a federal system. Those were not the instructions that came to us.
You ready for me, ma'am? And we are not discussing independence right now, neither am I proposing federation. All I'm saying is that we are now discussing with you what you said in your statement on this Constitution, that you recognize, you confirm the recognition of the equality of status.
Okay, well, what we want from you today, Mr. Charles,
the structure, and this is what we can't talk about.
As we said, we want, if you could go through the clauses and tell us what amendment you would like to see.
Ma'am, the entire bill must be rejected by the people of Tobago in regard to this conversation we are having. Because I am trying to explain to you that I am going through the bill and you are now, I'm referring to the preamble, and you have now led me properly to the section that would have dealt with this, with the explanatory note at 1. And I am asking you, where could I find in the bill a provision which recognizes that Tobago status and Trinidad status will be equal? I have looked at the bill and I have not found any provision. And all I am saying is that we should put that provision in the bill to allow that to happen. We make a statement, but there is no provision. You're asking me to do the drafting. I am
I'm not
only
asking you to do the drafting, Mr. Charles. I'm telling you that at clause 5, we have said very clearly there'll be equality of status between the island of Trinidad and the island of Tobago within the sovereign democratic state of Trinidad and Tobago.
Do we know what?
And let me say that that particular wording came directly from the bill that was sent to us from Tobago. As we go through the bill, you'll be able to see that within that context, what the bill attempts to do is to make sure that Tobago is accorded the ability to ensure that they can make laws for Tobago. There are other things that are different from what you have now that are now in this bill. So all I'm asking from you is if you point me to a clause or the clauses that you have an issue with. I know you're saying that you have an issue with the entire bill, but if there are some specific things that you want to see amended, if you could point me to or point us to those things, I'd be deeply appreciative. Thank you.
Entire bill, because there is no structure in the bill. So could I go to it? There is no provision in the bill to deliver the statement that you say that is in clause 4 and 5. There is no provision. It's just a statement made. What we would have done with the bill that we submitted to you is that we look at the 11 matters that the Tobago people say are fundamental to Tobago's right to self-determination and so on, and what must be contained in the legislation. And we would have put those things in provision in the bill which we submit. You now take that and you have it as a statement, and there is no provision that will give effect to that statement.
All right, Mr. Charles, then could you point me to where the bill that you submitted said certain things, and we did not take that into consideration? Maybe if you did it that way, we might be able to see it. Tell me where you wanted in the previous bill the federal system. Can you show me that clause in the previous bill if you have the bill before you?
No, I am not dealing with that, and this is why I repeated federal type. But I am not dealing with that. I am looking at the provisions of the bill, the one we submit and the one you have now for public comment. I am looking at both things, and I'm saying the one we submit started off, first of all, about amending to define boundaries of the bill.
Madam Chair. Good
Yes,
morning, Maita.
Member De Freitas, you want to make an intervention here?
Yes, I would like to make an
Go
intervention
ahead.
because it seems that we are going around in circles, and I'm listening to Mr. Charles as well, and we seem to be stuck at this point. So let me just ask Mr. Charles for clarification. So in the clause in the bill that Madam Chair has indicated, where it speaks to the equality of status between the island of Trinidad and the island of Tobago, it starts with that. Now, when we are asking for what provisions in the bill that you are indicating does not fully allow for that, I'm going to ask you, most of the clauses in the bill treats with the concept of unitary state of Trinidad and Tobago, of which Tobago is represented both at the parliamentary level and, well, in cabinet now. And the fact that Tobago is trying to carve out a certain level of autonomy within that unitary state. If it is, Mr. Charles, that you are looking at Trinidad and Tobago as is represented in the unitary state at the parliamentary level, cabinet level, and every other level, and taking it to mean that Trinidad and Tobago means Trinidad and only Trinidad, well, then you're going to have some confusion when you look at the clause that says there's an equality of status between the island of Tobago and Trinidad. The provisions in the bill treat with Trinidad and Tobago, the unitary state, and everything that comes with that, and trying to carve out for Tobago a certain level of autonomy as was indicated when the original bill came. So the question I'm going to ask you now, as Madam Chair I think is asking, is that what clause and what provision in the bill that speaks to Trinidad and Tobago and the relationship between the island, the unitary state of Trinidad and Tobago, of which Tobago is actually represented, and the autonomy for Tobago that we are trying to achieve, what provisions in the bill causes a problem for you?
I may even tell you almost every one of them. And this is why I started to give you this.
So hold on. So let me ask a question, Mr. Charles. So where you see reference to Trinidad and Tobago as a unitary state in the bill, do you see that as Trinidad only? Or do you see it as Tobago also being represented where there's reference to Trinidad and Tobago?
Let me take my time, sir. Are you prepared to hear me? Are you prepared to listen to me?
Yes, I'm prepared.
And I'm prepared. I listen to you attentively. The first thing we did is that you are preparing for a legislature to give Tobago its autonomy, self-government, internal self-government at that, not independence. And the first thing is that we are going to have our legislature, that we are going to be passing laws, and we know that law is policy. And as you know, that law is policy, and you know what you know that is what it is. And as you know, law is the tool for the implementation of public policy, or government policy. Now, the first thing we need to do is that, and we did that before, is that we need to know what is this Tobago, so that when we pass a law, what is the jurisdiction over what area should that law be applied? Other than that, you are going to enter places that you're not responsible for. And I am saying to you, the definition of what is Tobago is not there in the bill. And then the structure that goes in place with the power to do those things, not in the bill, because everything is going to be countermanded and overridden by the parliament, almost every single section. We can pick them out and read them for you. Every section, the cabinet still will be making policy, and all Tobago can do is to pass laws. You can pick up the entire piece of legislation, what clause it is. We in Tobago can only pass laws on about 4 or 5 issues. If you have it, about 4 or 5 matters. The rest.
Mr. Charles, I'm going to ask the Attorney General to make an intervention now, Member Al-Rawi, and then I'll ask Member Jolene John to make an intervention. Go ahead, please, Member Al-Rawi.
Thank you very much. Good morning to you, Mr. Charles. Madam Chair, I would just simply like to say, when we make reference, first of all, to a bill, we are dealing with 2 pieces of law in circulation for public consultation. The first one that we're dealing with is an amendment to the Constitution of the Republic of Trinidad and Tobago. That is the supreme law of the Republic of Trinidad and Tobago, as per Section 2 of the Constitution. When we are discussing Mr. Charles's concerns, which I thank him for being so careful in expressing, Mr. Charles, are you with me? I'm not sure, Madam Chair.
He's there. Go ahead. He's hearing you. Go ahead.
Okay, thank you. My screen wasn't in gear. Yes, Madam Chair. When we're looking at this, the first point made by Mr. Charles is that there's no definition of Tobago. There is a definition of Tobago. The second point is that he made a statement that there is a structure that Parliament effectively overrides. There are, according to him, 5 matters that they have autonomy in not being able to be overridden. But that respectfully is not necessarily the case. The most important point that I'd like to make here is that the instruction that came to the committee is that Trinidad and Tobago is looking for a system of autonomy, not a system of federal status, and not a system of succession or independence, and not a system of non-unitary factor. It's because of the unitary instruction where Trinidad and Tobago remains a Republic of Trinidad and Tobago that constitutionally we have difficulties in law in applying the concepts of federation into a unitary state. So I'd like to ask Mr. Charles, he made a very important point that I'd like him to please take his time to amplify. What are the 11 points that you referred to that you wanted to see in the bill? If you could list them for us so that we can have a clear understanding of what your 11 points are, please, sir. Thank you.
Sorry. Thank you, Member Al-Rawi. Before Mr. Charles goes there, I'd like Member John to make her intervention.
Thank you, Chairman.
Member John, just 1 minute, please. Mr. Charles, sometimes, and I'm not sure if you're not muting properly, but we keep hearing you when you're not on. So please make sure that you're properly muted. Yeah. So we're still hearing you. Okay. Member John.
Thank you, Madam Chairman. I was really happy to see Mr. Charles, the Honorable Charles, confirm that the consultations, the prior consultations, were very detailed. So at least he's satisfied with that. And basically, I think the major sticking point in terms of what I'm getting is that he's making the assertion that there is no real equality of status between the islands. But one would have pointed it out that in clause 5, it is here. It is in the bill, but I think yet he doubts that what is in the bill is meant by what is in the bill. And I hear the chairman when she's making the point that I think it will be helpful to the committee if he can just go through the bill, perhaps clause by clause. I think that is a quite generous offer, and just say, well, in this clause, we are not happy with this, and it differs from what we had sent or what our intentions are. I think that is what you're trying to say. I think so.
Yeah,
if
that is accurate.
Yes, okay, thank you.
If you can.
Mr. Charles, may I ask that if you wanted to send us the 10 points or 11 points in writing, that would assist us. But Member Indar Singh has an intervention.
Well, lead me to, based on what you are suggesting, Chairman, if Mr. Charles and his team may need some additional time to document what they want to put before the committee.
In that regard, as I said, it could be sent to us in writing immediately, and we will be able to examine what it is. Mr. Charles, is there anything else that you would like to raise with us?
I thought that,
Because there are other stakeholders who have joined us, and we can hear from other stakeholders in the meantime.
I thought somebody had made a suggestion that if you look at the Constitution Amendment Bill, and I think it's Miss Senator John Jolene, and you go through it and just raise the item, clause 1 or clause 6, and hear my objection to it or hear what I mean concurrence with it, it will help you. And that does not detract from the fact that Tobago will, and I repeat Tobago again, will submit what they would have agreed upon that should be contained as Tobago's responsibility.
All right. As Senator John said, yes, we can do that. I have been giving you that generous offer for the entire morning.
I thought it's you.
It's three of us. But go ahead, Mr. Charles. Tell us.
I thought you were
from clause.
Yeah, you were going to take the clauses.
Right. So we're at clause 7. So tell us, clause 7, what is the concern? And you can go through the clauses and tell us what the concerns are. So we're at clause 7.
Clause 7 is the one that talks about the chapel.
Constitution Amendment Bill. The Constitution Amendment Bill, we're at clause 7 because there are 2 bills before us.
Yeah, I'm looking at the Constitution Amendment Bill. We don't have a problem with, because that is what should be there. That if you look in, if clause 7 starts with section 5.2, with 5.2, that's, we must have a Tobago legislature if we have to make policy in Tobago and implement them or pass laws. So there must be.
So we go on to clause 8 now.
And I am not saying that I want to discuss the way this is drafted and to say whether I agree with this drafting. I am dealing with policy. Strict policy matter. And that's what I am dealing with. The way it's drafted, I'm not discussing the drafting.
Right, we know that.
The Attorney General's suggestion is one that I think that we will submit the information to you.
Okay, so you want to go on to clause 8, if you have some concerns about clause 8?
Yeah, but there's a 4th schedule, if you notice clause 8. And this is what I'm saying, clause 8 would have spoken to the fact that we are going to be given the power to make laws. That's what the legislature is all about. But then what it went on to say, that the Parliament of Trinidad and Tobago, we are only making laws that would not be affecting Trinidad, but the island of Tobago and the people of Tobago. But your Parliament can override those laws at any time. Our laws cannot be in conflict. So we don't agree with it.
Okay, but Mr. Charles, remember, it is not your Parliament and my Parliament. It is the Parliament of the Republic of Trinidad and Tobago, bearing in mind all the time that we remain a unitary state. So it is the Parliament, which is the supreme lawmaking body of Trinidad and Tobago. But because of according internal self-government, the Tobago Legislature will be able to make laws for the Tobago Island. So it will continue to be the Parliament of Trinidad and Tobago and the Tobago Legislature making laws for Tobago. The AG wants to come in here, and I'll ask the AG to intervene at this point, please.
Madam Chair, Mr. Charles has very generously accepted the invitation to reduce his concerns, the 11 points that he has raised. So I thank him sincerely for agreeing to that. I wanted to make the point, but you have made it very clearly and succinctly that there is not your Parliament and my Parliament. Your Parliament and my Parliament would exist in a federal system or in a state of succession where you are leaving the unitary state of Trinidad and Tobago. So I just wanted to join you in making that observation. So I look forward to Mr. Charles's point. Last point that I'll say is that I must remind that the purpose of consultation on a bill involves looking at how the policy is drafted into law, and that we cannot simply discuss policy by itself. We must look at the manner in which the prescription for the policy is delivered And clause by clause is intended to make sure we got the prescription for the policy right. So I'd encourage Mr. Charles to also guide us on his concerns on that end. Thank you so much.
Before you stop, could you perhaps just explain clause 8? AG?
Madam Chair, is that an invitation to me or an invitation
Yes,
to...
to you to explain clause 8.
Yes, ma'am. I'll happily
in terms
do
of the
that.
drafting of clause 8.
Sure. Give me a moment just to pull it up. Okay, so clause 8. Forgive me, I'm scrolling as we speak. Clause 8 seeks to amend Section 53 of the Constitution. Section 53 of the Constitution is a critical section of the Constitution where you have the power to make laws for the peace, order, and good governance of Trinidad and Tobago. That's the general provision in Section 53. It is the power by which the Parliament of the Republic of Trinidad and Tobago has the ability to make laws to govern Trinidad and Tobago. In causing an exception to Section 53 of the Constitution, we are stating specifically that the Parliament of the Republic of Trinidad and Tobago now has a caveat. The caveat is set out by the introduction of new subsections set out in Clause 8, subsections 2, 3, 4, 5, 6 of the proposed additions to the Constitution. This is an entrenched provision in the Constitution, and therefore introducing this amendment is a very critical and very powerful step to ensuring that what is set out cannot be changed easily or lightly. In the proposed amendment of Clause 8, you will note that subsection 1 and 3 of the Constitution of Section 53 are being modified so that the Tobago Legislature may make laws for the peace, order, and good governance of Tobago with respect to the matters set out in the 4th schedule. At subsection 3, we say that the power of Tobago Legislature to make laws shall not extend to altering the provisions of the Constitution. That is the entrenchment provision that you cannot amend the Constitution by a Tobago Act of the Tobago Legislature. And secondly, that in subsection B, we are saying that special majority laws, laws which are amended by special majority considerations, i.e. amendments to the law which affect special rights set out in sections 4 and 5 of the Constitution, shall be outside of the power of the Tobago Legislature. The reason for that is quite simple. The conflict of laws would be very significant, and also too, the danger would be the savings law may inadvertently be thrown away. I'll give you an example. If the Tobago Legislature were to say that we are no longer exercising the death penalty, which is a saved law pursuant to Section 6 of the Constitution, but which affects the right to life, which is a Section 4 right in the Constitution, there would be a conflict between the Tobago law and the Trinidad law, which when you look at it from a unitary state of the Republic of Trinidad and Tobago, may have the consequence of throwing all of the law out. This runs to the root of things like specific repeal and implied repeal. In the provision set out in subsection 4, where a Tobago Act is inconsistent with an act passed by Parliament, the act passed by Parliament prevails. Again, this is a very carefully worded position, which is common in all examples of autonomy states. You can look to St. Kitts and Nevis, you can look to Tanzania, you can look to lots of other jurisdictions. When we deal with this, we have to state what law is in prevalence because of the implied repeal argument in law. Sometimes we pass a law, we don't expressly intend to modify another law, but the rule is that the more recent law will amend the older law, and there is therefore the concept of something called implied repeal in law, therefore stating which law is to prevail. That is the national law of the Republic of Trinidad and Tobago, and perhaps I should say the Republic of Tobago and Trinidad equally, because they are unitary. That is why that provision is there. At subsections 5 and 6, 5 says, subject to 6, the power of Parliament to make laws having effect in Tobago shall not extend to any of the matters in the 4th schedule. So the combination of 4 and 5 effectively say anything in that 4th schedule is within the exclusive domain of the Tobago Legislature, does not include 3/5 majority legislation or legislation which will affect special rights set out in section 4 and 5 of the Constitution. And I can tack on saved law, which is in section 6 of the Constitution. They are all in that part. Subsection 6 says, at any time when it's expressly declared in an act passed by Parliament that a provision, being a provision relating to the 4th schedule matters required to have effect in the island of Tobago in the interest of external affairs, national security, state of public emergency, or in relation to a national financial crisis, then in those circumstances, and here's where we need a small adjustment, because at the word that should go out into what we call the shoes. It should not be a part of section D of paragraph D. That provision shall accordingly have effect in the island of Tobago, and where there's an inconsistency between that provision and the provision of Act, the provisions of the Act of Parliament shall prevail. So these provisions are critically necessary, again, because of the unitary state. States of emergency are not permitted under Section 9 of the Constitution to be exercised as a partial state of emergency. There is a state of emergency, and that state is the Republic of Trinidad and Tobago. National security and external affairs or foreign affairs, there is one unitary state. So for instance, it is not intended that the island of Trinidad can go on its own to the United Nations and make representations to the United Nations as Trinidad by itself. Similarly, when we look at financial crisis, as we saw prevailed in the collapse of the Clico Empire, and when we had to exercise Section 44 of the Central Bank Act to have powers of entry, there is a unitary aspect of financial crisis, and we have international obligations that we must comply with on those bases. This takes us, Madam Chair, to the provisions of Schedule 4 and Schedule 5. Those are set out in very clear terms at the back of the Constitutional Amendment Bill, and I'm sure that there would be some concerns that members may wish to discuss on those. The 4th schedule lists the matters that the Tobago Legislature shall have exclusive lawmaking power, and they are set out in very similar terms to what we see in the Caribbean context. And again, I draw example from St. Kitts and Nevis as well, and those are specifically set out. It takes us to the 5th schedule, which is administrative, and that is tacked on to the power of what a cabinet can do versus what I will call the cabinet of Tobago, or the executive authority of Tobago. I hope that has lent some clarity to your questions, Madam Chair.
Thank you very much, Member Al-Rawi. Mr. Charles, can we move now to clause 9?
Ma'am, I'm still, and even though we have to end here, put it back. Yeah, even though we have to end here, what the Attorney General would have just said, if we look at where we are from 1996 with the very Act number 40 of 1996, that we have had in operation for that while, Section 25, and because it could not have been passed with a special majority to affect the Constitution and so on, it says without prejudice to Section 75(1) of the Constitution, we know what 75(1) says, the Assembly shall, in relation to Tobago, be responsible for the formulation and implementation of policy on a number of matters. They are in the fifth schedule.
Yeah,
and
correct.
there are about 33 of them. Now, in this amendment to the Constitution, you're now saying to Tobago in this amendment to the Constitution that we are now going to be having exclusive lawmaking power on a few items. And in the fifth schedule, you would have taken away some of those responsibility of Tobago and put for us to implement policy, formulate them and implement, mean that we must pass with laws and implement them. We are now going to be responsible for carrying out a decision that is made elsewhere by you in Trinidad. And I say in Trinidad. So we are going backward, and this is why I said this bill is actually clawing back responsibilities that we had. I thought that we would have moved a long way, and that be coming here now where we are in 2021 to finalize what was decided by the Parliament in 1976.
Okay, Mr. Charles, let me just say that the fourth schedule deals specifically with what the lawmaking powers of the Tobago Legislature will be, specifically the lawmaking powers. And you will recall that right now, what the THA can do is only make bylaws
No,
for
we cannot make
Tobago.
bylaws.
However, what would happen now is that you are able to make laws for Tobago, laws, not bylaws. And the fifth schedule outlines executive powers. And there has been no attempt to constrain the executive powers. Perhaps the fifth schedule may need to be broadened a bit in terms of how it's written, but there has been no attempt to constrain that. And the only areas that you would not have executive power over would be national security and foreign affairs and very other limited areas. In terms of the lawmaking power, that lawmaking power is extremely wide and is set out in the fourth schedule. So I just wanted you to be sure that that is what the situation is. And it's not any attempt to constrain Tobago in any way, because the Tobago Legislature will be able to make laws, not bylaws. And what I would, so could you tell us if there are any other specific clauses in the Constitution amendment that you would like us to look at specifically, that you want to talk about now, or that you would put in writing?
Madam Chair, let me just clarify this issue based upon what you just said, because this is in the public domain. And what this is saying, the fourth schedule, is that Tobago will now be responsible for and lawmaking is formulation of policy. Formulate, like making and passing laws. Right now, under the fifth schedule, under Section 25, we represent Tobago House of Assembly Act. It didn't say subject to even the cabinet, it says without prejudice to. What the fifth schedule is saying is that you are making the decision in Trinidad with respect to our agricultural lands and fisheries, our community development, our culture, and all these matters that are there. And Tobago is to implement what you say. Don't matter.
That is not so, Mr. Charles. Sorry,
Madam
Mr.
Chair,
Charles. Sorry, that is not so, Mr. Charles. That is not so.
Could you explain it to me?
Yes, I'll do that again. The fourth schedule refers to the areas where there will be specific lawmaking powers of the Tobago Legislature. Laws for Tobago, laws. What Tobago can do now is make bylaws. Tobago cannot make laws for Tobago. Secondly, so that is a vast improvement. Secondly, with regard to the fifth schedule, that outlines the executive powers of the Tobago Island government. the executive powers. So it's a lawmaking power and executive power. Of course, there will be overlap because once there is a policy, you may need legislation to implement the policy. What exists now is not that. You have executive power now in Tobago in various areas, but you cannot make laws. What this legislation will be doing is ensuring that you have that legislative capability, and always within the context of the unitary state of Trinidad and Tobago and in accordance with the Constitution of Trinidad and Tobago. And I think the AG wants to make a comment here. AG?
Thank you, Madam Chair. Mr. Charles, I really thank you for taking your time to explain to us what your thinking is, but Madam Chair captured it completely. What we have said with exact certainty is what Tobago can do. It takes all of the administrative autonomy that it used to have in the THA, plus more. It takes legislative functionality in a way that it did not have before. It can make its own laws. The only exceptions to the laws are a special majority law affecting a right in Section 405 or anything in Part 1, which is states of emergency, save law, etc. Forgive me, save law, that's at Section 6. And it specifically says that Trinidad and Tobago may not separate itself from the Parliament's overall role only where there is a conflict between the laws or you step outside. Because obviously when you say one person can do X and one person can do Y, the law must be prescriptive enough to contemplate if there is a conflict, if there is a collision between factors. And that's why the prescription on the agreed policy is set out the way it is. Thank you, Madam Chair.
Thank you very much, Member Ravi. And let me amplify this to Mr. Charles and say that it will now be in the Constitution of Trinidad and Tobago, in the Constitution. And this section of the Constitution, once it is passed, will be passed with a special majority.
Ma'am, and I believe that we may end on this because we are going down the same road. I'm saying to you, I'm reading your Constitution Amendment Bill. It says before me under the 5th schedule that the Tobago Legislature will have lawmaking powers in respect of these matters that are listed there. That's what it says. And law is the tool for the implementation of public policy, whether it's THA or the central government or whoever wants its public policy. That is what we are responsible for. In the 5th schedule, it says that these are matters for which we would have just administrative powers. So somebody will be making the policy, and then we will have to just be managing it and carry it out in Tobago.
No, Mr. Charles, please. That is not, let me say, that is not what it says. The 5th schedule is headed, the list of responsibility areas for which the Tobago Island government shall have exclusive administrative powers in Tobago.
What is meant by that?
The 4th schedule has said the list of subjects for which the Tobago legislature shall have exclusive lawmaking powers in Tobago. And the list is very extensive, both lists. Both lists are extensive. And let me say, maybe we need to change the word. But when we say exclusive administrative powers, it is the executive power. These are the areas, and this means the entire of Tobago, unless something is accepted. And very few exceptions have been made.
Quickly.
So, Mr. Charles, I hope you're not confusing executive with administrative, or that because we have listed it as administrative, it means that we, as you say, Trinidad going to be sending things for you to be able to do in Tobago. That is not the intention. And if you read the Constitution Amendment Bill in its entirety, you would see that it all leads to ensuring that Tobago is given what Tobago wants, which is to be able to make laws for Tobago with policy and to be able to control its own destiny in terms of the executive that is in charge of the Tobago Island government.
So, Chair?
Speaker Chair.
Yes, could you, Member Dylan Remy, please make your intervention.
I'm just asking a question to see whether this may clear up the concern that Mr. Charles has. And the question is, can Tobago make laws for the matters that are in the 5th schedule?
The Assembly or Tobago cannot make any laws, not
No, sorry. No, Mr. Charles, I'm just asking in the proposed bill that is here. This is just to clarify your concerns about the 4th schedule and the 5th schedule. The 4th schedule says here you shall have exclusive administrative powers in Tobago. And you are saying that you cannot make laws for these areas, right? Because the other, right.
Them.
So I'm just asking the chair and the Attorney General, based on what is written here and what the law is intending, whether Tobago will have lawmaking powers for the areas in the 5th schedule.
Okay, no. Member Dylan Remy, the 4th schedule is specific. The 4th schedule says the list of subjects for which the Tobago Legislature shall have exclusive lawmaking powers in Tobago. It lists agriculture, and you also have exclusive executive powers for agriculture. It lists areas like hotels, housing, industries, land and buildings, other than land and buildings of the state, parks and other places for public recreation, prevention and control of fires, sport and cultural activities, and any matter that is incidental or supplementary to any matter referred to in this list. And it is very specific, borrowings of monies and so on. All of those are the exclusive lawmaking powers in Tobago. And then we have the exclusive executive powers in Tobago, and that is another very long list. So I think what we have attempted to do is to ensure that the areas excluding national security and foreign affairs are the ones that have been excluded in terms of lawmaking powers. Everything else, with few exceptions, have been given to Tobago in the 4th schedule to be able to make laws for Tobago.
Madam Chair, could I just please add to what you have said?
Certainly.
In answer to Member Dylan Remy's inquiry. The 5th schedule, there is a distinction that we need to understand. 4th schedule says, go ahead and make laws exclusively for the matters set out in the 4th schedule. That 4th schedule is tied on to the springboard of Section 53 of the Constitution. Section 53 of the Constitution is the power in the Constitution, the springboard in the Constitution that says, listen, you can make laws. We have amended that to say now Tobago can make laws. We've amended Section 53. Then you spring from that board and you go to the 4th schedule. You set out what they can make laws for. The caveat to that is no 3/5 majority laws, no laws to affect the special majority considerations, the rights set out in Sections 4 and 5, and to affect save laws. The caveats are national security, financial crisis, external affairs, for the reasons that I have mentioned earlier. The 5th schedule is to continue and broaden the power recognized by the courts of Trinidad and Tobago with respect to administrative responsibilities. Administration means if the Ministry of Education is doing something and it's to be rolled out by way of decisions, that Tobago has the authority and only Tobago to affect that part of the equation. That has sprung from litigation coming on the 5th schedule of the THA Act. The springboard is located in Section 75 of the Constitution. Section 75 of the Constitution is where a cabinet would normally have the collective responsibility to make decisions and to administer them. Now that is being amended, and Tobago's executive, I'll call it the Tobago version of the cabinet, Tobago's authority has exclusive control for administration. The law must be, therefore, improved the way we did. Number one, legislative making power pursuant to Section 53 of the Constitution as amended. And secondly, administrative power beyond doubt by amending Section 75 of the Constitution. I want to point out that this is much more than what existed before. The THA Act itself was not entrenched in the Constitution insofar as administrative powers were done. What we did in the Constitution in the earlier days when this was dealt with is we amended and we included the Tobago House of Assembly. So this is a dramatically important improvement to the constitutional functions of Tobago for legislative function and for administrative function. Thank you, Madam Chair.
Thank you, Member Al-Rawi. Mr. Charles, let me just remind you that everything was in one previously. The entire assembly was one. What we're going to have now is an assembly that is a legislative part of the assembly, and we will have the executive part of the assembly. Hence, the schedule, the two schedules try to give that distinction very clearly. So there'll be the lawmaking powers and there will be the executive or administrative powers.
Madam Chair.
And it would mean that it would be two entirely separate arms of the state or the island government of Tobago.
Madam Chair, having regard to all that have taken place so far, I want to just make this in closing. That, and I started off by saying that we are totally disappointed at what we arrive at. And Tobago recognized that we are a sovereign democratic state. We recognize that. The document we prepared and sent down there, and that sovereign democratic state, as is stated in Section 1.3 of the Constitution, says that we are a sovereign democratic state consisting of the island of Trinidad, forget the other things, and the island principally of Tobago. And what we did was to amend to make sure that the public administration of the island of Trinidad in a sovereign democratic state is in the supreme law of the country, and the public administration of the island of Tobago that consists the state is in the supreme law of the country. Why we prepare one document? The procedure that you are following is to ensure that Tobago remains subordinate to Trinidad. In fact, what you have done here by this document is to colonize and entrench the colonization of Tobago in this constitution. And I am sad. I have worked on this with everybody, including you and you all. And I am so sad to know that we have gone back there. I have read every contribution in Parliament. from 1976 on the Tobago matter. In 1996, I have read everybody's contribution, including every independent senator, every member of the opposition. Those are in government right now today. And when I see this document, I recognize that there have been no change at all in the attitude of the PNM government towards Tobago. And I didn't want...
Mr. Charles, I'm sorry that you feel that way, but let me remind you that the Joint Select Committee is not the PNM. The Joint Select Committee is made up of members of Parliament, not the PNM. So I'm sad that you would think that way, but Mr. Charles, I understand your feelings. I want to thank you very much for your participation, and I would look forward to you sending us your concerns in writing. And I would also look forward to us having these continued discussions, but we are moving to a point where we would like to bring this matter to the Parliament for debate. But I thank you for your contribution today, and I look forward to hearing from you further. Could I indicate to our viewers and listeners that we're going to take a break at this time, and we will resume within another half an hour, and we will return to you shortly. Thank you very much.
Constitution Amendment Tobago Bill. The proposed revised Constitution Amendment Tobago Self Government Bill will alter the Constitution of Trinidad and Tobago to enshrine into our Constitution certain rights exclusively to the island of Tobago. Tobago will become an autonomous region free to pursue its economic, social, and cultural development within the margins of the Constitution of the Sovereign Unitary State of Trinidad and Tobago. The bill clearly affirms that both islands are equal, none superior to the other. Therefore, any reference to Tobago as a ward of Trinidad is to be removed from all laws or other records wherever it appears. The Constitution will now establish the Tobago Island Government. Staff who work for this government will fall under the umbrella of the Tobago Division of the Public or Teaching Service Commission as proposed by the committee. Also, the Constitution will establish a completely new Tobago Legislature with the ability to pass laws for Tobago that will come into effect on assent by the President, similar to the process followed for the enactment of laws by the National Parliament. A companion bill provides workable financial arrangements and sets out